is Shantanu Singh and I'm a fellow physician, and soon I'll be graduating, and I'm in process of finding myself a job. And in the process I'm currently reviewing contract, and I have found out that there aren't many resources available where a physician like me, who is going to be going into their first job, um, can get an understanding about how a contract is laid. It is for that reason I'm making this video. I've had a chance to go over several resources, and I've compiled that. With that understanding, I want to share the same with you. So after you have been to a prospective employer and you have understood what patient-physician ratio in that location is going to be, what sort of group practice that is, whether you are going to be salaried by that particular group or by a third party, and you have an idea about all the questions, such as the place where you are going to be working at, is that on lease, or has that been bought, or are the partners in that practice, do they have shares in that particular property, and so on and so forth, because all of that actually affects your salary at the end of the day. So once you have been able to answer all those questions and you're satisfied, then you are and you have agreed to work with them, and the other party has agreed to hire you, then you are given a draft contract. Now there are several types of draft contracts or several types of contracts. One is an employer contract, and one is where you are a contractor. A contract is an agreement between two parties. A contract does not have to be fair. For example, in a contract there could be, they can say that you will be on call every other day. There could also be wording which says that in case someone falls ill, then you will need to cover. So that you may not feel fair about, but once you have signed, you have to abide by it. In short, contract is an agreement between parties. It does not have to be fair. So it is very important for you to know what is written in your contract before you sign, because once you have signed, it becomes a legal document. This is something that we are not taught during our training, and not many people know about it. So I have my contract in front of me, and I will be going over different parts in my contract, and I will be talking about the same with you. So when the contract starts, it'll say what are the parties involved in the contract. So you will be, of course, one of the parties, and then it will be either the group, the practice, or the employer with whom this contract is going to be with. There will be a start date, and that is very important, and there will be a legal binding date. So there will be a date when the contract is being signed, and then there will be a date when you are going to be starting your practice. So it's very important to know when you're going to be starting your practice for several reasons. About when you'll be joining, as you have to do several things, such as you have to obtain a medical license in that state, you need to be credentialed by insurance companies for that particular group, and you also need to have hospital staff privileges. One of the important things that you should be aware of is, for example, if your credentialing is not in place and you start working in that facility, there is a possibility that the group can start billing your patients under a different physician. This is a fraudulent practice. Just something that you should be aware of. I don't think practices are doing that. Then the next section usually is about duties. So in my contract it says duties. One can be working full-time with that particular group, or you could be working part-time. So that is an important section. your activities which are not related to the group should not violate the full-time group activities. And those activities could be such as investment. If you're investing somewhere, then you have to keep that in mind. The group has more than one location at several locations, then you have to be very particular about where you'll be working. There could be a place which is about 30 miles away, and there could be other hospitals which may be close by. So you may want to request to work in closer hospitals rather than you driving maybe once or twice a week at a location which is about 40 miles or 70 miles away. That does happen. Sometimes the contracts can have workload in that particular description, and oftentimes if that particular group has had issues with prior physician, it is that when they state workload, number of patients that one is expected to see. So this is kind of a red flag that you should be aware of. For example, let's say there is a group that is renting out a place in downtown New York, and they are having a hard time getting collections. So they may expect you to see about 30 patients in their practice per day, or 40 patients, or maybe a higher number. I'm just giving an X amount. And that amount may be needed just to sustain their practice, to be able to pay their rent, where they're hiring, to be able to pay third party for instruments, for etc. etc. But for someone who is coming in new, that volume may be a very high amount. So in those conditions, a group may put in a particular number that needs to be seen. Particular number of patients that need to be seen. And this just gives an idea that in the past, new physicians who have been recruited to the group may have had issues with the group, and so should be clarified. So the next section is ownership and setting of fee. Usually in a group, when you're employed, you have all the fee that is coming in to the group. So the group may say that you need to reassign your right to Medicare and other reimbursement to the group, which is okay, because you see patients, and the money that is coming in, or reimbursement that is coming in from insurance companies or copay, needs to go to the group, and then it will be distributed. The next section is honoraria. Let's say I'm going to be starting our practice, and this place does not have a sleep lab, and they decide to make me director of sleep. So for that particular title, I should be getting a certain amount of money, which could be $20,000 or $30,000, and so I need to make sure that, or it should be very clear that that how much of that money will I get. For example, if I work for a group, they may say that we want 20% of that money, 20% of 30,000, or they may say that we do not want any money in there, and all of that is yours. So you have to be very clear about how much money, how it is distributed. The next section is call coverage. So call coverage is very important, and it is in your best interest to make this part very clear, how your calls are going to be. Is it going to be one in every 5 days, or how often it is going to be? It should be very crystal clear. This section needs to be very crystal clear. Make sure that they do not have this wording in vague, because oftentimes if this section is vague, then it works to their advantage. They may say that you need to cover more calls. So this section needs to be very clear. I'm not saying that you will shy away from calls. What I'm saying is, for example, um, if your contract says that you are going to take one call every week, then and for somehow they have shortage of physicians where they're requiring you to take at least 2 calls per week, then you can put up your point and say that, this is not written in my contract. Since you're asking me to take more calls, you should also get reimbursed for that same amount. Whereas if your contract is very vague regarding calls, then they may just use you without reimbursing you for the same. So the next section is compensation. So the contract will specifically state how much and how often you will be paid. So your compensation can be either monthly or it can be on a yearly basis, but your contract is going to clearly state that. And a good source of that is MGMA's website. You can look at that. It has good division. So remember, the base salary is always negotiable. You should always, if you feel that that is not the right amount for you, then you should always tell them that this is not right and you're probably expecting a different amount. At the maximum, they're going to decline, but it is your right to ask for the amount. You have to remember, when you're signing a contract, they are also trying to take advantage of you. So you should also have the right to take advantage, or at least get in what you deserve. And so you should be able to ask for what is right. The salaries are usually paid on a bi-monthly basis or a monthly basis. And the salary that is written is actually the gross amount, which is the total amount collected by a particular group. That is the gross amount. And so the employer can withhold the amount for Social Security, for Medicare, and for other employment taxes. So the number that you actually see on the contract may actually not be the right amount that you'll be getting. You'll probably be getting a lower amount than that. So your net amount is going to be a lower number. That should be kept in mind. Now, it is very important to understand what their formula compensation is. That may not affect you in your first year or second year, but that is important. For example, let's say you join a practice and you're getting 400 or 500K at a location, whereas at a different place for the same job you are getting 250 or 300K for the first 1 or 2 years. But at this place where you're getting a higher amount, and you have to remember that this amount is only given to you for 1 or 2 years until you are able to set up your own practice or you're able to make your own patient base. And after that, it all goes to production based. That means how much you can generate, you get. So some places may give you a higher amount right away, and they will tempt you to sign the contract there. However, 1 or 2 years down the line, once that base has gone away, you may figure out that you're not able to even generate the amount that was equal to your base. And this is something that you should keep in mind. So you should always ask them to give you formula compensation for everything. You ask them for examples. Okay, like, if I were to see 10 patients, and or if I were to do 10 bronchoscopies or 10 e-buses, then how will I be compensated? If I were to read PFTs, then how will I be compensated? So this may not affect you in your first 1 or 2 years, but this will start affecting you in your third, fourth, fifth year. And if it starts affecting you and your net income or your gross income is less than your first 2 years, then there could be consequences, both for you and for the practice. Just something that you should keep. So remember that virtually all compensation formulas are based off your gross net income. That particular practice may not bill right away, as you may still be in the process of credentialing with insurance companies, and the income from those insurance companies may start coming in after 60 or 90 days. So just keep that in mind. So that lag in the amount can affect you, how you're paid. Now in a group, there is something known as ancillary services, and you should be very clear about inquiring how you will be paid based on those ancillary services. For example, let's say I work for a big group which has about 20-30 physicians, and that group has their own PFT lab, they have their own laboratory where they do blood draws, they have their own imaging center where they do CT scan, PET scans, chest x-rays. Now when you have such a setup, you'll be ordering tests, and those tests are going to be done in-house, most likely. So that is known as ancillary service. So now when you get so that particular group that is ordering it usually keeps an account. There is someone in the group, and that they keep an account of how those tests are being ordered and how much the hospital or that particular group is generating from it. So you need to be very clear about how you are going to get your part from ordering those tests. You don't want to just let go away of reimbursement from ancillary service. So that needs to be clear. Are you going to get a certain percentage? Are the seniors in the practice going to get a higher amount than you? So that just needs to be clear. So if your compensation is based on a formula, then just make sure that you don't have to repay any advances, any advance payments caused by shortage in your production, and that's important. So when you're usually starting out, you want to have a salary while you're making a patient base, and then eventually move to production base. The next section is term of contract. So most of the contracts are either 2 or 3 years, and they could be longer or shorter. And then there are some contracts then that do not define their term, which is, in that case, it is indefinite, which means that the contract is going to run until it is terminated by one party or the other. And at times there will be a contract that may have the term evergreen or automatic renewal. So if that is the case, then it says that the contract is going to be automatically renewed within 90 days before the end of the contract, unless either of the parties are terminated. The next important topic in my contract is termination, and this is a very important section that we should have an understanding about. So a contract can be terminated in case of death or disability. So usually disability means that you are not able to perform your essential job for a particular number of set days. So that is what disability means. And this period could be over 90 days or 180 days. So there is a particular number of days that may be defined in your contract, and so this term is known as qualifying period. So you need to make sure that in your contract it is very clearly stated that you will continue to get your salary in that qualifying period. You may find that sometimes the salary only continues for a period of that qualifying period and not for the entire period. So make sure that you're aware of this provision. Also keep in mind that the employer can have a provision stating that you may be subjected to examination by employer's physician during your disability. So just keep that in mind. So it is very important that you also have your own personal insurance, your term life insurance and your personal disability insurance, other than the one that is given by the lawyer, just in case, let's say if the employer is not giving you income or salary for that qualifying period or entirety of that qualifying period, then that may be trouble for you. So that is important to keep in mind. For cause means that one of the parties has a reason to terminate the contract, and typically the contract will contain a list of for cause with little or no choice. So for example, there could be a list saying that your contract will be terminated if you are involved in sexual harassment, or if you kill a patient, and certain things. So some of the for causes are standard and have to be there. But your interest is to make sure that the for cause list is short. It should not be vague. Let's say, for example, if your for cause list says that if you're absent, then your contract will be terminated. So that does not clearly state absent from what. So there is a possibility that you were sick and or you were quarantined during the COVID season, and that's the reason you were absent. But they may use that against you to terminate your contract. So you have to be very careful about the for cause list, what is stated there. If there is anything vague, try to get that removed. The items ideally you should have in your for cause list are such as loss or suspension of your medical license, or loss of hospital privileges, or exclusion from Medicare program, or if you are not able to be insured for your malpractice, or conviction of a crime. So I think that is a better for cause list than something which is vague, where you are where the hospital or administration uses it against you in your term. Things like unbecoming conduct is very vague, so try to not have such clauses in your contract. Sometimes in the contract you may have, and oftentimes you may have, if you do not abide by policies of that particular. The next section is vacation. Now, in general, you get about 3 to 6 weeks of vacation in a year, and so this is an important part as well. Are you going to be paid during vacation? Are you going to be salaried? So some places may salary you, may pay you, other places may not pay you. For example, let's say you are working in a group practice that actually is paying initial first 2 years, you were getting a really good amount of money. Let's say you're getting a 90th percentile of what your specialty is, and then in the third year, and you did take vacation in your first 2 years, and you were even salaried at that time. But starting third year, when that base salary you're not getting, and you're supposed to produce, which is production based income, and then you start taking vacation. In that vacation that you're taking, about 4 or 6 week vacation, you may not get paid, and your overall income falling in the following months may actually be on the lower side, and you may start to feel that. So you have to be careful about how your vacations are. Are you going to be paid during vacation? If you're not being paid for vacation, and then then what do you do? The other thing that you got to keep in mind is some places may allow you to stack vacations until the next year. For example, one of the hospitals that I work at allows employees to stack their vacation for maximum of 80 days until the next year or year after. So what that means is, let's say if I'm allotted about 2 weeks of vacation at that particular hospital, I don't take that vacation that year, and I want to take it the next year. So I will be able to take 4 weeks of vacation the following year. So some places may do that, other places may not do that, just something that you should be aware of. Other thing you need to be aware of is, are sick leave days going to be counted in your vacation days, or are your conference days going to be counted in your vacation days? Just some of the things that need to be very clearly stated in your contract. You are always going to be professionally liable. You may have professional liability insurance that your organization or your group gives you, so you should always take. That goes without saying that one should always have a malpractice insurance. Now the question about malpractice insurance is, how much of malpractice insurance should you have? I don't know the answer to it. Some may say that you should have a higher amount, others may say that you should have a lower amount. So I can give you an instance. For example, let's say you have $1 million insurance, whereas your colleague has a $3 million insurance, and you are in the same specialty, and a lawsuit is filed against your group, and both you and your colleague were involved in that lawsuit. When the lawyer for the other party takes or reviews your case, they will definitely be looking at how much money can we extract from our insurances, our malpractice insurances. So someone who has a $3 million coverage may be the point of target more than someone who has just $1 million. But again, I'm not an expert at this, but just something to keep in mind. So there are two types of insurance policies. One is claim-based and one is occurrence-based. So claim-based insurance is, let's say I work at a particular hospital between 2020 and 2021, and if a malpractice lawsuit is filed against me while I'm working there between 2020 and 2021, then that insurance will cover me. Now let's say in 2022, if a malpractice lawsuit is filed against me while I was working at that location in 2020 and 2021, then I will not be covered. So that is claim-based. Whereas occurrence-based policy is slightly different. So let's say if they file a lawsuit against me in a future time for something when I was working at this group in 2020, 2021, then they will still be covering me. So that is occurrence-based. So occurrence-based insurances are a little more expensive, but they are, but one should have them. They are, I feel that they are better. They are more expensive though. Now, if you don't have that insurance, then you might need to get, if you have, let's say, a claim-based insurance, then you might need to get tail coverage, which may be very expensive. It depends on specialties. For for maybe someone like me who's in pulmonary critical care, it may be in 5 digits. whereas someone who is an OBGYN or a surgeon, it may actually be in 6 digits just to have it for a few months. So you have to make sure that you have the right amount of insurance, you have tail coverage in case you're leaving one job and going to the next one. So this should be very clear. So before an insurance company gives you an insurance like a malpractice insurance, they will have you, they'll ask you for a lot of information. So it's very important that you tell them everything, that you give them all the correct information. If you have had any malpractice insurance or any lawsuits filed against you in the past, you must inform them, because they are going to be able to find that out. It is widely available data, and this is available in National Practitioner Data Bank. And let's say if you hide some information and later on they find out and there is already a lawsuit against you, then they may not cover you, and that's going to be a big problem. Now let's say if a lawsuit is filed against you, then the insurance company is going to give you a lawyer, but it is up to you to retain that lawyer or a different lawyer. That lawyer the insurance company gives you may or may not be experienced enough, but it is up to you whether to retain that particular lawyer or a different lawyer. So once you are leaving the practice, and if there is a case filed against you, then both you and the group that you had been working for are going to be liable for that malpractice. So it's very important to know what your tail coverage is going to be, which means, let's say you have claim-based insurance. Once you leave the practice, you will need tail coverage, which means in case you were to have any malpractice any malpractice filed against you, then there should be coverage for both you and your employer or your ex-employer. But let's say if you have occurrence-based insurance, then you do not need any of that provision. Now let's say if you were to get tail insurance, the duration of tail insurance can vary. Some can be as short as 1 year, the others can be as long as 7 years. The longer the tail insurance is, the much more expensive it is. Some of the states have a particular limit till when one can file a lawsuit. For example, let's say if someone filed a lawsuit against me in 2020, then January of 2020, then they have in my state, if the rule says that within 2 years you are the patient party can file a lawsuit against me, then they have January up till January 2022 to be able to issue a notice against me. But if they think of issuing a notice against me in 2023, then they may not be able to. So what I'm trying to say is that every state has a limit till when you can file a lawsuit against a physician, and based off that, let's say if it's 2 years, then you can just think about getting a tail coverage for maybe 3 years or 4 years. You don't have to get it for 7 years, because that's going to be more expensive for you. So let's say if you have claim-based insurance, or the employer gives you claim-based insurance, then also in that contract the employer should mention what happens or who buys tail insurance. So in some of the contracts, they may expect you to buy tail insurance. If that is the case, then you must tell your employer that the employer should buy tail insurance coverage for you, regardless of who terminates the contract, whether it is you who terminates the contract or aware of that policy. Then the other section could be indemnification, which is a legal term that requires one person to pay another for losses sustained. If you find this term in your contract, just try to have them remove this clause altogether. Next section you may have is restricted activities and convenient not to compete section. So courts view convenient not to compete as a restriction on trade that will be enforced only to minimum extent necessary to protect legitimate interests the employer has in the employment relationship. As a result, the employer must have an interest that requires protection such as a trade secret or confidential information or specialized training. So there are three specific items in our case, which is geographic scope, duration, and restricted activity. So geographic scope typically refers to a linear radius. So you have to be very familiar with the geographical location that you're working at. For example, a non-compete may contain that you are not going to be able to work in a radius of 40 miles or 80 miles. So what that means is it's a radius, it's a linear radius rather than transversed on the streets or roads or interstates. So keep that in mind. Subspecialties may have a longer linear radius, whereas specialties may have a shorter linear radius. You also have to keep in mind if you're working in a metro area versus in a rural area. For example, 5 miles of linear radius in downtown New York could mean a lot more than 5 miles in rural West Virginia or rural Kentucky. And there are several consequences to it. And we will discuss that eventually. Length of time. So this needs to be very clear. And most of the lawyers feel that the length of time should not exceed more than 2 years, with 1 year limit being very common. It should be clear on the type of activity that is going to be restricted in the non-compete. For example, if I were to, let's say if I leave a practice and I go to a different location, and in my contract they mentioned that I cannot work in pulmonary medicine, then I can at least work in critical care and sleep medicine at a different location, so I do not violate their non-compete. It's very important that you have it's very clearly written what your limitations are going to be. So you should try to negotiate this section. Try to have this non-compete clause deleted altogether. But let's say if the employer does not delete this section, then you may want to negotiate and say that just in case in your first year or second year, if you were to leave, then this clause not be applied to you. You should also have them not apply to you in case they terminate your contract without any. This actually non-compete can have a dramatic impact on you as a physician. For example, let's say you have a family, you have kids, and you're settled down in a particular location, in a particular community, and suddenly you are terminated, and this non-compete comes into action. In that case, you essentially won't be able to use your skills in another location within that particular radius. So that puts you out from several practices in that locality. For example, let's say you were terminated, you practice in Manhattan and you were terminated, and you cannot practice in a 5-mile radius. So then, and you're a specialist, so then you have to go to a different location. You have to build up your referral base and then start working from scratch. So that is a lot. So just be aware of these negatives. So it's best to avoid non-compete. Confidentiality covenants. So this is a section where a particular group may have their secrets. They may not want you to share those secrets with anyone else when you leave that particular place. Just keep that in mind, that there is always a period to this. Maybe it could be 2 years or 3 years. So make sure you have that in your contract. And this secret could be anything. So you have them define what these confidentiality secrets are. So if they have this particular clause, then you want to have the employer also include carve out. So carve out. So carve-outs exclude confidential information that you learn from other sources or that is generally known to the public. Non-solicitation is another section. So this comes under 2 varieties. So first, the employer will ask the physician employee not to solicit or employ any of their existing employees. And the second variety is that you will not contact patients or referring physicians with whom you had contact during your employment. Overall, to get an idea about what a contract is and what to look for in your contract, and hopefully this video is going to help you. Again, I'm not a lawyer and this is not a legal advice. You must speak to your lawyer for legal advice.